So there are two methods to an insurrection determination in American law. One is a civil route through Section 3 of the 14th Amendment. The trouble there is you have no private right of enforcement of Section 3 of the 14th Amendment. So it has to be paired with some other right, normally an election right, as was done in Colorado, or somehow by federal election mandamus based on a prior ruling or fact in the law already. The other path is through criminal route or definition of criminal law through 18 U.S.C. 2383. The path through Section 3 of the 14th Amendment has to be where one uses an insurrection or rebellion against the Constitution of the United States. It means something has to be done that is trying to usurp or defy what's set out in the Constitution. And in this case, with Mr. Trump, it would be Article 2, Section 1, Clause 1, in his attempts to stay longer than 4 years. On the criminal side, 18 U.S.C. 2383 doesn't require any prior office or any prior oath taking, and it is defined in its language as whosoever incites, sets on foot, etc., etc., to defy the authority of the United States or the laws thereof. Functionally, the Colorado court used the 18 U.S.C. 2383 standard. This is what happens when you have a state judge who doesn't deal with constitutional issues normally, trying to rule under federal law. Judge Sarah Wallace ruled that Mr. Trump ruled as a judge that Mr. Trump incited insurrection and therefore engaged in insurrection by inciting it. Now, to her credit, all she had to do was interpret the argument before her. And when it came time to rule, there was a problem in the law in that the difference between the two statutes is one, on first blush, requires an oath of office to support the Constitution. The other is it requires you having previously been an officer. 18 U.S.C. 2383 requires neither. There is no incitement to insurrection by the constitutional path. So she ruled under 18 U.S.C. 2383 by incitement. And further on in the video, you'll see Mitch McConnell, the day of Mr. Trump's second impeachment proceedings in the Senate, actually cast the definition out there. He says it is a part of our criminal law, what the House of Representatives charged him with, and he is correct. So, Judge Wallace, in her ruling, not knowing federal law, actually sliced and diced and tried to cut it apart and mixed the two up. First of all, Crew, the organization that brought the suit, proceeded down the wrong path. They never, from what I can see, defined the rebellion or insurrection against the Constitution of the United States, which means they would have had to argue that Trump's scheme to stay in power was what the insurrection was, not January 6th. They argued January 6th. So that put it down the path of 18 U.S.C. 2383 with the incitement. And that's how the judge ruled. She also then tried to rule that it doesn't apply to Trump because he doesn't have taken the disqualifying oath and that he wasn't an officer of the United States. Well, what she ruled under doesn't require that. Now, whether Crew is going to make that point up the appellate chain, no one can tell. They're pretty hard-headed. They've got it wrong this far. There's no reason to think they're not going to continue to get it wrong. They had a success in New Mexico, which was the Cooley-Griffin case, which was a quo warranto case. And they've modeled everything after that. But this is not quo warranto. This isn't trying to remove someone from office who's in office who engaged in insurrection. This is trying to keep someone out of office by mandamus, making the Secretary of State keep them off the ballot. And that requires to use Section 3 of the 14th Amendment, and that means showing that he engaged in insurrection or rebellion against the Constitution of the United States. Well, Judge Wallace has actually handed a complete win, but until they recognize that, it's not going to matter. Anyone else in the country can pick up the order and by judicial notice march into a federal court, preferably, and seek federal mandamus under election laws. Because the finding of engaged in insurrection is not going to go away. It may be engaged in insurrection by incitement to insurrection, but that doesn't matter. What matters in this particular case is that there is an engaged in insurrection ruling. And in this case, going before a federal court with this order in tow by judicial notice means arguing she finished the congressional impeachment standard of incitement to insurrection, and that carries an automatic bar to office. She may not have had the power to fine him and jail him in this election proceeding, but the ruling, the facts of the law and the ruling are going to stand. That nothing there is incorrect except her conclusion under Section 3 of the 14th Amendment. But she doesn't she doesn't rule under Section 3 of the 14th Amendment. She says she does. So technically she does, and that means to appeal it, Trump has to go back to Congress and then say, okay, the judge got this wrong. I am not... he can't really argue it. He has to get a ruling from the court. He has gotten a ruling from the court that leaves him in a pickle, because the only way out of this is to convince 2/3 of both houses of Congress to remove that engaged in insurrection bar. There is no appellate path to that, because that is what she ruled under. Not the standard she used, but what she ruled under. She ruled under 18 U.S.C. 2383, but that's not what the petition says. The petition says Section 3, the 14th Amendment. So here's some information across YouTube of various professionals casting their expert opinions, none of which seem to understand what actually happened. So as they say, let's get into it. I'm so tired of cussing. Here's Trump screaming at the top of his lungs because he's just been screwed by the Colorado Section 3, 14th Amendment ruling. It uses a standard of 18 U.S.C. 2383. No one's quite realized that yet, because the judge found him guilty of insurrection by incitement, inciting the insurrection. That doesn't require as high a standard, but how that's used, I don't know. So here's what it is. Under 18 U.S.C. 2383, it's also self-executing, and Judge Luttig described how and why it's self-executing. There is no standard, there is no cookie cutter boilerplate that a court has to use to find one guilty of any of the types of insurrection or rebellion. And there is a sentencing guideline of $1,000 fine or imprisonment and a bar to holding office. So if a court construes that as the manner in which insurrection was adjudged, even though it's under the criminal code of the United States, in an election proceeding, there is nothing. It's just facts and law. So she used the law of 18 U.S.C. 2383, and to know that she spoke of that anywhere, it doesn't matter. If it's under the law of the United States, and if on appeal someone has to argue it, well, there it is. So Section 3 of the 14th Amendment is kind of moot, because he's barred from office under 18 U.S.C. 2383. There's no prior oath required, and there's no oath of office standard required. So the two things that she said he was exempt from in this case do not apply. There is no listing of offices, and there is no oath required. It's just anyone who does that. Anyone who incites, blah, blah, blah. Go look it up yourself, 18 U.S.C. 2383. So, Toddler Trump is drumped. He's done. It'll just take a minute, but he'll get around to the fact of realizing he's screwed. Here is 18 U.S.C. 2383, rebellion or insurrection. It's supposedly a criminal statute, but it's only a definition and a sentencing standard. It says whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States. Now, the key here is shall be fined under this title or imprisoned not 10 years or both, and shall be incapable of holding any office under the United States. Here's the deal. If you're not charged with 18 U.S.C. 2383 in a criminal case, but the statute is utilized in a mandamus voting procedure, the hearing of being disqualified from the ballot due to the insurrection, all they had to do was sufficiently prove that someone incited the insurrection against the authority of the United States or the laws thereof, or gives aid and comfort thereto. It means you shall be incapable of holding any office under the United States. Now, the court can't jail him. The court can't fine him because there is no criminal proceeding. This is a civil proceeding, but it can use this definition of law. Oops. It'll take a minute. It'll take a minute even for crew to realize that the court just ruled entirely in their favor and sidestepped Section 3 of the 14th Amendment because there were two loopholes there, and she cited them. The president isn't listed. He may or may not be in office of the United States. And the oath is an issue, as Trump's attorneys argued. Well, this way, neither matters. It just says whoever. Doesn't matter if you took a prior oath. It doesn't matter at all. It doesn't matter whether you're an officer of the United States, held prior office. It doesn't matter. All you have to be is a whoever. That certainly is Trump. He's a whoever. So, we'll see if crew wakes up. Section 3 of the 14th Amendment is kind of moot. (18 U.S.C. 2383). It's normally a criminal statute, But all law is definitory. It has a definition. You can use criminal definition in civil statutes, civil cases. It's just that you can't put them in jail without an indictment. You can't do certain things. But Jack Smith is using this, and in his latest filing, he did cite 18 U.S.C. 2383, but didn't go any further than that. Smith, however, does have a criminal case, and as Judge Luttig showed and said, the reason this was not charged is Jack Smith would have run into a First Amendment issue with Trump. So, Judge Wallace was either insanely smart and ruled against him by making it look like she ruled in his favor, and nobody has caught on to it yet. Or this is the dumbest case of stumbling upon the perfect storm in legal history. I think it was the first one. She knew exactly what she was doing, and this was the way to find him guilty. She let him stay on the ballot for now, but subject to review by the Colorado Supreme Court and maybe other courts in federal nature. We'll see what happens down the road, but it comes back to this 18 U.S.C. 2383, and there is no oath of office required, and there is no officer of the United States, prior officer of the United States required. It's just a whoever, and Trump falls right in there. Okay, so there's been a success of sorts in the Section 3 of the 14th Amendment efforts. After court after court after court dismissed, denied, without addressing the merits, Colorado court, due to a mandamus feature in the law as to the Secretary of State, Jenna Griswold, who's scared out her pants, actually wrote an extensive 102-page ruling, which you can find, on the internet or here on this site. The site is gov-shout.com/remove_Trump with remove and Trump capitalized. It's a running blog of sorts. It has a sample letter to send to a Secretary of State, which asks them to remove Trump from the ballot. But now, with the ruling from Colorado, you can modify it, or it can be modified, or I think that it will be modified to include this ruling. The ruling appears to give Trump a victory, but it doesn't, as you will see Lawrence Tribe describe in a few minutes. What it does is it finds that he engaged in insurrection and that Trump was not an officer of the United States, and that he did not take an oath to support the Constitution, both of which are such thinly veiled escapes that anybody can do a Google search on President, Officer of the United States, and up will pop information from the DOJ and a court case called Buckley versus Vilios. I don't know. It's on this site here, on this page, link to it. And any court could just say that was error. We will adopt the order without that error. And then as to support the Constitution, the word defend is a synonym to support. So the ordinary dictionary definition meanings or synonym meaning would apply. And there you have it. He would be barred by Section 3 of the 14th Amendment. Trump's only appeal, proper appeal, is to Congress. Now, this is new. On Sunday, the 19th, the Colorado Supreme Court will hear the appeal. There's an accelerated briefing schedule, but it doesn't matter because that ruling will not get reversed. It may get clarified and take care of the officer of the United States issue and the support or defend issue, or they will try. But it doesn't matter. The Colorado State Court at the trial court level or the Supreme Court level, neither one of them can interpret the Constitution of the United States. Only a federal court can do that, all the way up to the Supreme Court. Now, in this case, that's interesting because guess what? The Supreme Court has no jurisdiction. The jurisdiction is cast to Congress. And Lawrence Tribe, further into the video, explains why. It didn't trust the executive or judiciary to deal with these insurrectionists from the Confederacy. And that's why Section 3 of the 14th Amendment was written. And here we are again today. Trump is trying to be Jefferson Davis. He's trying to lead an insurrection to basically destroy the country as it's formed and turn the Constitution into some kind of autocratic hierarchy. Well, we all know it's not going to work, but he's putting the country through hell while he tries. Now, the ruling from Colorado is also found on this site, and it's here. Now, let's just take a quick look so you'll know what to look for. This is the actual order from the Colorado court. And, you can read the whole thing. It's 102 pages. Doesn't matter. Because at the end, there's two things that make the order what it is. She finds that Trump engaged in insurrection. Okay, first check. Then the second thing is that he's not an officer of the United States and that the oath that he took does not support the Constitution. It's not one to support the Constitution. Well, they both fail because law from the Supreme Court, as I previously mentioned, says otherwise. So, all 102 pages of this order work against Trump. He's been politely screwed. Now I'm just going to spin to the end to where she says that. I encourage you to go to the site, download the order, and read it yourself. It's not hard to read. It's hard to get to the end of this because it's 102 pages. Where am I here? I'm on page 77. Oh, okay. It's a PDF file. It's only like 3/4 of a megabyte. And it's a very detailed order. Now there it is, her signature, Sarah Wallace. And she concludes that as a result, the court holds that Section 3 of the 14th Amendment does not apply to Trump. Now, yeah, he's above the law. He's above the law. She talks about here the presidential oath. They did not intend to include such a person. But this is what judges can do. She tries to say preserve, protect, and defend, which is in the presidential oath, is not support. And preserve, protect, and defend. Well, preserve and protect doesn't mean, actually, all three words mean support in this context. But defend is a direct synonym for support. So, a federal court would be forced to look at the corrections and then rule accordingly. Now, somewhere here is the site to Buckley and there it is. Buckley versus Vallejo, 424 U.S. 1, at page 125 in 1976. The Supreme Court said, "We think that the term officers of the United States, as used in Article 2, which is Article 2, Section 1, Clause 1 is what Trump is violating, is defined to include all persons who can be said to hold an office under the government." End quote. Of course, the office of the presidency is an office. So, at this point, I don't think Las Vegas would take a bet that Trump is going to make it to the general election. He won't. The Supreme Court is going to have a hard time. The U.S. Supreme Court will have a hard time with this. But they may decline to hear it because they don't have jurisdiction. If they decline to hear it, they should say, according to Section 3 of the 14th Amendment, the final sentence, only Congress can deal with this. After correcting the errors, Trump is barred from office, and only Congress can relieve that disability. So, let's take a look at the first video clip. Trump is cooked. It amazes us. It's so amazing is how he's so stupid. How this guy doesn't understand anything. It's really, really amazing. And sadly, his children aren't too bright either, although Ivanka's the only one that seems to have a brain. The nut don't far too fall from the tree.
The judge decided the 14th Amendment does not apply to Trump because the wording does not specifically mention the president. The nonprofit behind the lawsuit to remove Trump from Colorado's ballot plans to appeal. And in Michigan, another bid to block Trump from running is heading to the state Supreme Court. With me now is Christopher Maddy, former federal corruption prosecutor and partner at the Koskoff Law Firm in Connecticut. Thank you so much, Chris, for being with me tonight. I want to first get your reaction from the Colorado judge ruling. What is the first thing that went on in your mind?
Well, I mean, the most stunning revelation from the court's over 100-page ruling was that the court concluded that Trump engaged in insurrection against the United States. The court went through a lengthy analysis as to what the founders meant when they described insurrection, and concluded that Trump had engaged in the force or the threat of force to interfere with the execution of the laws. So to see a judge conclude that a former president of the United States did that was stunning. But it's also true that the judge concluded that even though President Trump had engaged in insurrection, the 14th Amendment of the United States, according to this judge's reading, does not apply to former presidents of the United States. The text of the 14th Amendment essentially says that anybody who has engaged in insurrection against the United States, who has previously taken an oath to support the Constitution of the United States, may no longer hold public office. Here, the court concluded that the president is not among the offices that that amendment applies to. But also what the court said was that it was mindful that were it to rule otherwise, it would result in the disqualification of a candidate for president of the United States. The court essentially invited an appellate court to review the decision to decide whether or not the 14th Amendment prohibits Donald Trump from being a candidate for president.
Right, I think that's what's interesting, right? Perhaps Donald Trump is smiling today, but then you have people like scholar Lawrence Tribe. And Tribe argued that the Colorado judge actually handed down a defeat for Trump. Take a listen to what he said.
She threw him a lifeline that was so thin, so threadbare, so likely to fall apart, that although he could claim victory, no appellate court could uphold putting him on the ballot on that basis.
So where do you see this case going?
It seems right. I mean, the judge essentially construed the 14th Amendment, which prevents somebody who is engaged in insurrection, who has previously been an officer of the United States, from holding office again. She concluded that the presidency is not an office of the United States. So I agree with Professor Tribe that, that seems to be a bit of a tortured reading, that if it is true that he engaged in an insurrection, and an appellate court is going to have a hard time overturning that factual finding, it seems that President Trump, under the 14th Amendment, is not eligible to be a candidate. Now, an appellate court would have the same quandary that the trial judge had, which is, are we going to prevent a leading candidate for president of the United States from being on the ballot? But if the Constitution requires it, that's what they have to do.
That's right.
Speaking of the insurrection, there's so much here, but of course Trump also asked to remove references to the Capitol riot from his federal election interference indictment, but of course the judge said no. Why did Trump try to censor his own charges? What's the strategy there?
Well, look, I mean, I think Trump is very concerned that he's going to be tried in the District of Columbia before a jury who witnessed the events of January 6th firsthand. And so it's really not surprising that he's going to try and limit his involvement in those events in any way that he can. But Jack Smith's indictment makes clear that although Trump is not charged with inciting insurrection against the United States, he is alleged to have been a cause of the violence on January 6th, which is the same finding that the Colorado judge that we were just mentioning made. So it seems to be a kind of futile effort to try and disconnect himself from the events of January 6th, but it appears that's what he's trying to do.
Judicial notice.
Maddie, thank you so much. Really appreciate it.
Judicial notice is going to get him.
Remember that phrase, no one is above the law? Or how about this one? How does it go again? Let me get it right. If the president does it, it's not illegal. It's starting to come back to you now, isn't it? Well, today there's a new one for the history books. A Colorado judge finding that Donald Trump incited really an insurrection or intentionally engaged in behavior, and quote, therefore engaged in insurrection within the meaning of Section 3 of the 14th Amendment, saying he acted with specific intent to disrupt the Electoral College certification of President Biden's electoral victory through unlawful means, specifically by using unlawful force and violence. something that, well, we were watching the day it happened, January 6th.
We fight. We fight like hell. And if you don't fight like hell, you're not going to have a country anymore.
The judge saying Trump did, quote, everything in his power to fuel anger before January 6th. And if, by the way, he were anybody else, he would have been disqualified from office. But because he was the president, that law does not apply. The judge saying the 14th Amendment's insurrectionist ban does not actually apply to presidents, because the oath the president takes is not the same as the oath for officers of the United States. But that sounds a lot like someone is above something, doesn't it? Almost exactly like, since the president did it, it's not illegal. I mean, talk about whiplash. And if you're confused, you're not the only one around these parts. Up till now, we'd heard primarily, I think, two arguments in this case, not unlike what we heard in places like Michigan and Minnesota, who already decided to keep Trump on the ballot. One of the arguments was that it should be up to the voters, not any court, to tell you who was on the ballot. The other argument, since Trump had never been charged with insurrection and there had been no legal conclusion that he actually engaged in it, and there's no reason to take him off the ballot because of course, due process and that presumption of innocence that we all hold very dearly. Well, today it didn't seem to come down to the voters' argument, and the judge did say that he did incite something. Instead, it came down to what's called a technicality, if you will. If the founding fathers meant for the president to be removed by this mechanism, then they would have clearly stated that. Instead, they mentioned officers of the United States. I want to dig in more here, though, because the Section 3 actually says this: who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state. They didn't say the president. You see that? It's almost as if, and this is something I've heard a lot recently, there's a two-tiered system of justice. I want to get right to Noah Bookbinder. He's executive director for Citizens for Responsibility and Ethics in Washington, the acronym known as CREW, the organization that also was involved in this very case in Colorado. Noah, thank you for being here today. A lot of you have been following this for a long time. We knew about Minnesota and Michigan, but Colorado was different because they had an actual sort of trial on the merits about the underlying facts of an insurrection. Are you surprised by tonight's decision that he is going to still be on the ballot, according to why the judge said so?
Well, I mean, I think the most significant thing in this ruling tonight is this ruling that Donald Trump did incite an insurrection by a judge who heard days of testimony, thousands of pages of evidence that was submitted. That's, I think, the most significant thing. This ruling about the president not being an officer of the United States, we obviously disagree with that ruling. Our plaintiffs are going to appeal that. That is a legal, strictly legal ruling that the Colorado Supreme Court is going to have its own chance to evaluate. But the thing that was unique in this proceeding that already happened was that evidentiary hearing with days of testimony, with reams of evidence, and the judge looked at that and found that Donald Trump incited insurrection within the meaning of the 14th Amendment, and I think that's the most significant takeaway.
Given that takeaway, you think you will appeal. You know,
yes.
You've got a pretty thin window, though, because, of course, ballots have to be printed. I think it's January 5th, I think is the date in Colorado. So the window is very small of when you can appeal, have that essentially be resolved, and then the ballot still
Except
printed.
the U.S.
Is there
Supreme
enough
Court has
time
already
to get that
decided
argument made and maybe
in
resolved?
Buckley
There absolutely is enough time.
what's an
There is
officer of the United
States.
States.
There is a legal procedure in place in Colorado to resolve these questions quickly, understanding that ballots need to be printed. Mm-hmm. So it skips intermediate appeal.
It includes the
up
president.
to the Colorado Supreme Court. In other cases where people have been challenged as disqualified on ballots, not presidents usually, but the Colorado Supreme Court has taken them up very quickly. We expect that to happen here. So we're going to move quickly, and I think we found
CREW
a lot,
and Bookbinder
to be
screwed
very
this up
encouraged
because
at
they
in
should have
what
never
came out of this ruling
retried
today.
the
The
issue.
fact that, and I know you pointed out the idea that
Congress had already
obviously in the
decided
appellate court,
this.
Their job is not to relitigate the facts, but their job is to think about the legal arguments being made. And we disagree in some way in the conclusion. The judge seems to have teed up in a way by having a very narrow ruling. It's a long opinion, by the way, but a narrow ruling to suggest it's because he was the president and the language of Section 3 does not contemplate a president. Do you think that the Colorado Supreme Court on appeal, or maybe even the Supreme Court of the United States or other courts that might look at these issues over time, are going to buy that it is narrow enough to exclude it, to keep him on the ballot?
You know, I think it's been instructive that really top legal scholars across the political spectrum.
If Bookbinder knew what he was talking about, he would know about Buckley.
A famed conservative judge, came out very strongly.
He was the one in the part of the impeachment hearings who talked about and wrote the different things, and it came out in the hearing. Yes,
exactly. He came out today and said that while he agreed with the factual parts of the judge's decision, he feels very strongly that the president is an officer of the United States, and that part of the judge's decision was incorrectly ruled.
That interview is behind this one.
Conservative law professors Bowd and Paulson, who have studied this in great depth, reached the same conclusion. So we think that there's a lot of weight of opinion on the other side of this one, and a real shot to see that go the other way, particularly given that ruling supported in so much fact that Donald Trump did incite an insurrection.
So based on that, I mean, this is Colorado. There's already been some litigation in places like Minnesota and Michigan. They did not have a trial. Procedural issues kept them from resolving it fully. But are you going to bring litigation in other states? Because there are 50 of them.
Well, the first thing that we're focused
Except
on
the
doing
insurrection is not insurrection, it's rebellion.
The next step. We think we got
rebellion against the Constitution of the United States.
102-page opinion, many pages.
102 pages, and it's not mentioned.
Zeroing in on
Article 2, Section 1, Clause 1, and his attempt to stay past 4 years. That's the rebellion against the Constitution.
By the way, why did you choose Colorado?
They've
We
missed
chose
it.
Colorado because it had
We'll see what
a
happens.
statutory system in place. It had laws that said voters can go to court to challenge a candidate who is not qualified, and you can get into court quickly, and if the court finds someone not qualified, the Secretary of State has to remove them from the ballot. So it's got that procedure. It's a fast procedure. It's a relatively early state in the presidential primary system, so you can get in there early. And we had these fantastic Republican and unaffiliated plaintiffs who were willing to
Except
bring
they argued it wrong. The complaint was written wrong. It should have been mandamus. It should have relied on what Congress already did.
Protect our republic.
A method to the litigation madness.
Charged with incitement to insurrection, brings the bar to
Trump's
office.
attorney was on CNN tonight giving a preview of how they're going to argue, likely, on appeal. Listen to what they said.
We'll argue to the Colorado Supreme Court a lot of the same arguments we made before, which is the textual and historical analysis of the 14th Amendment, especially considering the fact that the way our Constitution is set up, the way our republic is set up, is people get to choose who gets to be their president. We shouldn't have courts striking people from the ballot. We're also going to,
It's not what the Constitution says.
Erroneous argument that President Trump engaged in an insurrection. We think that's just flat out wrong, certainly contrary to the evidence. It was a little bit unusual for her to spend a lot of time talking about that.
So what exactly
Except
happens
he's
now?
right.
Will that argument work on appeal? That's the real question for so many people. I've got just the guests for that very question. Let's get right to Marcus Childress, former January 6th Committee Investigative Counsel, and Rebecca LeGrand, a constitutional lawyer and defense attorney. I got to ask you, first of all, you've already heard, Marcus, and you heard obviously from Noah as well, the January 6th Committee report and the information that was gleaned and really shown to the country and the world was relied a lot by this judge. That was criticized by Trump's counsel because they took a lot of issue with what was presented in those hearings. Were you surprised it was relied on to the extent that it was?
Except that they rely on
Look, we're where we trusted our process. We trusted that we went where the facts took us.
The issue
arguments about bias from our
of
committee,
Article
maybe the
2,
qualifications of our committee,
Section
but
1,
there were
Clause
no,
1,
assertions contrary to
the
our
engaged in
actual findings of
insurrection is going to fall
that
apart.
former President Trump incited this insurrection. And you saw the judge actually discuss that in her opinion of the reliability of our investigation and how methodical we were with that. And I think that the fact, it was a great confirmation of the work that we did here today. And I was happy to see that she confirmed it.
I mean, you almost had it confirmed. Well, you explicitly had it confirmed by one Senator Mitch McConnell right after all the presentation of the evidence back after that impeachment. I mean, listen to what he had to say. I mean, he was aware and confirmed it then. Listen.
The House accused the former president of, quote, incitement. That is a specific term from the criminal law.
Now that's
No
18 U.S.C. 2383.
That President Trump is practically and morally responsible for provoking the events of the day. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
And yet, Rebecca, the holding tonight was that, well, because he was the president, he's not accountable under that letter of the law.
That was the holding today, and I share Marcus's view that this was a careful, detailed opinion that confirmed a lot of things that folks have been arguing about and held and addressed directly a lot of Trump supporters' arguments in a context where there was due process, where there was a chance to cross-examine witnesses, where Trump could put on witnesses and did. So all the due process you want. And after listening to many days of testimony, reviewing the relevant portions of the January 6th report, this judge found this was an insurrection. This was an insurrection, and Donald Trump was responsible for it. And those are powerful findings.
Except the insurrection isn't important. It's the rebellion against the Constitution, Article 2, Section 1, Clause 1.
And is inartfully drafted for these purposes, as we might say. So she's struggling with this language that was designed for the Civil War, where lots of elected representatives had rebelled, and we're trying to figure out what to do with them. But the president, Abraham Lincoln, didn't. So the people drafting that weren't thinking about what just happened here. That's what makes it a hard question. Yeah. So the judge, I think, carefully analyzed the language. She ended up going with an argument that had been out there, that had been made. I heard it mainly.
If it goes to the Supreme Court, they could just say,
Casey, who made pretty much this exact argument.
There was no insurrection against the Constitution of the United States.
Marcus, I'm asking on that point. I mean, we're talking about the validation of having this.
There was a riot.
But we can't look at it in a vacuum, can we? I mean, he's got criminal matters that are happening, including one involving January 6th, right here in Washington, D.C., under Judge Chutkan, just to name one, right?
Now, there's the insurrection.
Election subversion cases as well, including what's happening
as well as Georgia.
Could what happened today
That's the rebellion
have an
case.
impact on those?
I mean, speaking of the
both of those, Georgia
it was
and
pointed out in
D.C.
closing arguments, but former President Trump argued for removal in the New York case, the New York bank records case, and part of that argument for removal is he's an officer of the United States. But now
Not good.
in this, he's saying he's
Looks
not
like
an
bingo.
officer of the United States. And this was brought up by Noah's team, and clearly wasn't persuasive for the court. But I would imagine on appeal, I would hammer that point home because you're making contrary arguments depending on the jurisdiction. And so while it may not be expressly stated in the 14th Amendment, right, they're not being consistent with their arguments, at least to the court.
I guess you guys say you can't have your cake and eat it too. Well, we'll see what happens there. Thank you, both of you, so much. Marcus Childress, Rebecca LeGrand. Donald Trump is on the ballot. So what does another candidate have to say about that? Well, I'm going to ask one. Jill Stein is here next. Broken. She joins me for tonight's candidate interview. Jill Stein, thank you so much for being here this evening.
Now, this is who elected Trump.
I'm eager to get your opinion on
with
so
her
many
spoiler
things,
votes.
But I do want to get your reaction to this Colorado
in 2016
14th Amendment ruling. The judge saying that Donald Trump, quote, engaged in an insurrection, but will stay on the Colorado ballot. Do you agree with that?
You know, I am not a legal expert, and especially not in this area. This is the third case, as I understand it, to be decided in favor of allowing the voters basically to either accept or reject Donald Trump on the ballot. That sounds reasonable to me. I tend
That's
to
not
err
what the
on side of
Constitution
allowing
says.
voters to make decisions. But again, this is not my area of expertise at all.
Well, on that point, that was one of the big arguments that was raised. The question essentially.
Oh, let's let the voters
whose
decide
decision
if
should
Charles
it
Manson
be, and should
should
one's
run for
behavior
president.
foreclose that moment. So we'll see what happens, maybe other places. But now to your bid for the White House, because you've done this twice before. Once in 2012, also 2016. You never cracked 2 million votes. You didn't receive a single electoral vote. Why do you think the third time will end up differently?
Well, I think you can ask the voters why it is that they are clamoring.
She's just a
for
spoiler
choices.
candidate.
When you don't have exposure, when you're not covered by the media, when there are all
A
sorts
vote
of
for her
groups,
is a vote for
expensive
Trump
groups that you
because
have
it'll
to
take
jump
away
through
from
as
Biden.
a grassroots campaign in order to even get on the ballot. There are all kinds of reasons why independents and third parties have a very steep uphill climb. But, the voters are clamoring for more choices. And I would
Uphill
say,
climb,
who is
impossibility,
anybody to tell the voters
ridiculous.
that they don't deserve choices? This is really fundamental to our democracy, to our rights as voters, and to the integrity of our elections, is to have those choices.
There has been a lot of criticism about a two-party system for that very reason, frankly, and that when somebody who is not a part of either the Democrats or the Republican Party, they get a lot of criticism. They're accused of being a spoiler vote. In fact, you yourself was accused of that as well, accused of having taken away votes from Hillary Clinton in places like Michigan and Pennsylvania.
That's
and
exactly what
where
happened.
Trump's victory margin was smaller than your total votes. When you hear this complaint, based on what you've just said about who has the nerve, essentially, to tell the American voters who they can and cannot have as choices, do you think the criticism has been fair about your entrance into the races?
I think the criticism reflects a certain kind of arrogance that the establishment parties own your vote. They don't own your vote. They have to earn your vote. And, the studies and the statistics are very clear that people
two
who vote
parties,
Green,
you vote for anyone else, you're taking or casting votes to another person.
Would not have come out to vote at all had there not been a Green or someone with a Green agenda been on the ballot.
You don't know
it's
that.
Completely invalid to suggest that those votes belonged to Hillary Clinton, and I think it reflects a kind
No,
of
they did
arrogance
belong to Hillary
of the,
Clinton.
Establishment parties to presume that voters owe them.
What a denial witch.
That's part of what people are rebelling against now in clamoring for other choices. It's a record high 63% of voters now who are saying that the two-party system has failed them. And, to look at the reality of people's lives now,
that's because the national popular vote has failed.
You have 60%, over 60% living paycheck to paycheck. 1 in 4 are
No, we don't need to hear that.
40% of renters who are severely economically stressed.
You're talking about something that you'll
young
never
people
have
are
anything to
saying that
do
they're
with.
hopeless about the future, and in fact that they feel betrayed and abandoned by their government on really critical issues, including the climate collapse, which is accelerating towards us right now. So I think those are all reflections.
Except the loser is not going to help.
For more choices,
You're not going to be president ever.
It only happens when you have challengers on the ballot, and I think.
Is this what women say? Whatever.
Sorry, go ahead.
Okay, I was going to ask you, but one of the things you did leave out, which is going to be very top of mind for many voters right now, in addition to everything you just listed, has been the Israel-Hamas war, and a lot of voters right now, particularly leaning in. And you have been an outspoken critic of Israel's ground operation in Gaza. One need only comb through your X account to see that you have been very condemning of the administration and the American response, and also what's going on in Israel. Do you condemn the actions as well of Hamas on October 7th?
I condemn all violence against civilians. Yes, absolutely. At the same time, I think one has to recognize that what we're seeing from the Netanyahu regime now is in a league of its own, and it's really it's horrific to witness. You have over 2 million people who are denied food and water and electricity, who are being bombed relentlessly for the past month. Half of the housing has been destroyed in Gaza. People have had to move.
While you're right there, Biden is taking care of
to
it.
safety, and they're being bombed as they do. You're seeing the targeting of hospitals and healthcare centers and refugee centers and press offices, as well as the press themselves. I mean, it's absolutely horrendous, and we are seeing, Israel now kind of being considered a pariah state. So it's not just that this is terrible for Palestinians, this is also terrible for Israel. And we're seeing countries who have repaired their relations with Israel, including Jordan, one of the few Arab countries who reestablished relations, who've now basically broken them off and recalled their ambassadors.
Yeah, well,
this is part of
Israel's sake.
The Jews returned in 48 and it all started.
Talk about what you would do, since you're asking me to be the
Moved
president
in
of the
on
United States.
land that
What you
wasn't
would do differently to try to
nationalized.
stop what is
Called
happening.
it
Dr.
theirs.
Jill Stein, we'll have to have that conversation another day. Thank you so much.
Sounds great. Good to be with you.
Joining me now is the aforementioned Judge Michael Luttig. He's a former federal judge of the U.S. Court of Appeals for the Fourth Circuit. Also with us is Lawrence Tribe, professor emeritus at Harvard Law School, co-founder of the American Constitution Society, and author of the important book, American Constitutional Law. Boy, do I need to talk to you two gentlemen this morning, because this one is way above my pay grade. Judge Luttig, let me start with you. Talk to me about this. We've tried our best, as you know we always do, to lay out what we believe the court was intending to say about this amendment. I would now love your interpretation of all of that.
Thank you, Ali, and thank you for having Professor Tribe and I on this morning. This is an historic decision. It will reverberate throughout the country from today through the 2024 presidential election and well beyond. The Colorado court decided, as you said, the most pressing constitutional question facing the nation, holding that the former president did engage in an insurrection to overturn the 2020 presidential election. You simply could not overstate the constitutional significance of this fundamental finding of constitutional fact and law by the court. I cannot imagine myself that this finding will be overturned by the Colorado Supreme Court, or for that matter, the Supreme Court of the United States. At the same time, the court did egregiously err in holding that the office of president is not an office under the United States. Turning constitutional interpretation upside down by finding the unambiguous text of Section 3 ambiguous because of a sliver of debate history that is not only itself ambiguous, but is rendered singularly unpersuasive by other exchanges in the debate history that reflect the understanding that the office of president is, of course, an office under the United States from which a person can be disqualified by Section 3. You suggested that this was a narrow interpretation of Section 3. It is that and more. It is the narrowest possible interpretation of Section 3. It's the interpretation urged on the court by the former president's lawyers, but it's simply incorrect as a matter of constitutional law.
Professor Tribe, Judge Luttig is a judicial poet, and he said something there that resonates with me entirely. And he said this court has rendered the unambiguous ambiguous, because ever since the two of you were on this show in August, I have been reading this clause. I've been reading the 14th Amendment. I've been reading Section 3, and I thought it meant what it meant. And this court has found a way to say, absolutely not, Velshi. Once again, your law and order training is not sufficient. Tell me what you make of this rendering by the court.
Well, I certainly agree with Judge Luttig that the most important decision rendered by the court is one that is not likely to make the former president happy. And that is that he deliberately engaged in an insurrection against the Constitution of the United States. The holding of this case, based on a week-long trial, detailed examination of the evidence, and as the judge pointed out, with ample opportunity for Donald Trump and his lawyers to make the contrary case, the holding in paragraphs 144, 288, and 298 of the opinion is that Donald Trump intentionally incited a lawlessly violent mob for the specific purpose of overturning an election that he knew he lost. In paragraph 100 of the opinion, she concludes he knew he lost the election. So what accounts for this bizarre, actually bizarro, upside-down holding that the highest office in the land, the one with the greatest power, the one whose danger to the republic is at its maximum, would somehow be exempt? The judge herself says, she admits, this sounds preposterous. That's her word. She says it would carry the preposterous implication that Jefferson Davis, who took an oath to the Constitution before becoming a senator, then became a senator, then turned on the Constitution, then became a Confederate and the president of the Confederacy, that he could then become president of the post-Civil War United States. She says, I know that's preposterous, but maybe the writers just goofed. Right. She says maybe it was inadvertent. They were not inadvertent. She says, for whatever reason, that's the way she reads it. My suspicion is that having built a wall of fact and law so high that no appellate court could climb over it, a wall that establishes that Trump was guilty of engaging in a disqualifying insurrection, she threw him a lifeline that was so thin, so threadbare, so likely to fall apart, that although he could claim victory, no appellate court could uphold putting him on the ballot on that basis. So she basically had it both ways. She laid the foundation for disqualifying the former president, gave him a fig leaf of victory, and set things up so that a reasonable appellate court would have to say, we agree with her that he was guilty of an insurrection against the Constitution, that he went way beyond free speech because he intentionally incited lawless violence. But we disagree with her, and she almost disagrees with herself when it comes to this weird holding that it was just the presidency after all. She even admits that although the oath is a little bit different, it has the same scope. The oath he took and the oath all other officers take, she says in footnote 39, covers the same obligations and imposes the same duties. So things are set up for a decision against Trump by the Supreme Court of Colorado. He will then seek review in the Supreme Court, and there all guesses are off.
I want to discuss what happens next. Judge Luttig, you had tweeted, the beginning of one of your tweets reads, the Constitution is not a suicide pact. The Constitution is not a suicide pact with America's democracy. Indeed, it is the very contrary in this instance. It is plain that the entire purpose of Section 3, confirmed by its literal text, is to disqualify any person who, having taken an oath to support the Constitution, engages in an insurrection or rebellion against against the Constitution. The former president did exactly that when he attempted to overturn the 2020 election and remain in office. Now, I'm going to ask PJ, my director, to put up my element number 2, which is the oath of office for the president versus the oath of office for, let's say, a federal employee. The presidential oath talks about preserving, protecting, and defending the Constitution of the United States. The federal oath of office says, I will support and defend the Constitution of the United States. The judge is saying that there are 2 parts to this. One is that the language of the oath is different, and the positions enumerated in Section 3 don't include the President of the United States. Tell me if either of these holds weight for you, if one holds more weight than the other, or neither do.
Neither, Allie. And let me first say, with respect to my tweet, what I was trying to remind the court and the courts in the future of is the constitutional axioms now that we are expounding a constitution here. We're not auditing financials. And in that connection, the other axiom is that the Constitution is not a suicide pact. All of that is to say that the Constitution must be interpreted differently than, for instance, a federal statute. And that's the starting place, I believe, of the state court's error last night. Now, turning to the 2 specific questions, the court last night held that the office of president is not an office under the United States. This, notwithstanding that the Constitution itself repeatedly refers to the office of the president, and indeed the presidential oath itself references the office of the president. So I don't believe that holding will withstand even an appeal to the state Supreme Court. Now, on the other question about the oath, a person disqualified under Section 3 must have previously taken an oath to support the Constitution. A president of the United States takes the oath that's prescribed in the Constitution. That oath is to preserve, protect, and defend the Constitution, not by its terms, literally, to support the Constitution. On the other hand, the disqualifying oath in Section 3 is an oath to support the Constitution. So the former president's lawyers, right out of the gates, argued that obviously the former president never took the disqualifying oath because he never took an oath to support the Constitution of the United States. He only took an oath to preserve, protect, and defend the Constitution. In my view, that argument borders, if it does not transcend the frivolous. I can't even imagine the Supreme Court deciding this case on that frivolous argument. The other argument that the office of the president is not an office under the United States is slightly more meritorious, but I believe is and Professor Tribe and I have long agreed that argument too it fails.
So, Professor Tribe, this all makes a great deal of sense, what you two say. I guess what never makes sense to me and my viewers is what's supposed to happen next, because we talked to you guys, we talked about what's likely to happen. We knew that it was the Secretary of State who would need to take some action on this. We spoke to every Secretary of State in the United States, and they said, well, clearly anything we do is going to be challenged in the courts. So then we started to wait for court cases, and then something like this happens. What, in your opinion, is the next likely thing to happen that will continue this discussion about Section 3 of the 14th Amendment?
Well, we know that the opening brief in the Supreme Court of Colorado is due Monday, this coming Monday. It's got an expedited schedule. We don't know exactly what that court will do, but we know it's on a fast track to the Supreme Court. But let me underscore the importance of something that Judge Luttig said. The idea that the most powerful office in the land, described over and over again in the Constitution as an office under the United States, should be exempt, would make the Constitution into a sick joke. What is it? It's an office over the Constitution rather than under? That is apparently what Donald Trump thinks. He has said he would terminate the Constitution. In fact, the net result of this holding is that all underlings are bound by this disqualifying oath, but because Donald Trump used the words as the Constitution required him to use, preserve, protect, and defend, and didn't use the word support, we can treat him as having taken the oath with his fingers crossed. What does it mean to preserve, protect, and defend the Constitution, if not to support it? And in fact, the whole rule of law would be shredded if we said that the president is above the law because his oath, because of its wording, exempts him from the most fundamental requirement of law. And that is that when your term is up and you lose, you leave. It's only dictators who get to stay as long as they want. That's why the fate of the United States and of democracies around the world is at stake in whether Donald Trump is allowed ever again to take the oath, whether to preserve, protect, and defend or to support the Constitution. He clearly isn't going to mean it, whatever words he uses. Right. That's the scary part.
Here is where you can find the entire interview. The ampersand T equals 426 S is a time jump to 426 seconds in. If you want to see the entire interview, simply remove that, or when the video loads, go to the control bar at the bottom and slide it to the beginning, and then you can watch the entire interview. It's worthy to note that the problem that exists between the Colorado ruling and what Judge Luttig is saying may be semantics, but if he was engaged in insurrection, it seems 18 U.S.C. 2383 will apply as a definition regardless. And that also carries a bar to office. So, one would have to read the order very carefully. This video is being made before the Colorado Supreme Court hears the appeal, which I believe is on an accelerated briefing and hearing schedule. It doesn't matter. There is an engaged in insurrection finding. There is a construction, or what's called a construing, of Section 3 of the 14th Amendment, which is in error because of the officer and the oath. Any court can take judicial notice, correct that, and rule against it.
And it seems to me that, frankly, all parties to these different litigations in the various states, to this point, have misunderstood Section 3 of the 14th Amendment. As I said, it disqualifies one who is engaged in an insurrection or rebellion against the Constitution of the United States of America. It does not, by its terms, disqualify one who engages in an insurrection or rebellion against the United States or the authority of the United States. And there is a world of constitutional difference between those two. It is, of course, to the former president's advantage for his lawyers to argue that Section 3 disqualifies one who engages in an insurrection or rebellion against the United States or the authority of the United States. But that's not what Section 3 actually says. But in both litigations, Allie, both parties have focused almost exclusively on whether the attack on the United States Capitol of January 6th constituted an insurrection or rebellion against the United States. Even more specifically, I've read some of the questioning by the judges from the bench. And it seems to me that, frankly, all parties to these different litigations in the various states, to this point, have misunderstood Section 3 of the 14th Amendment. As I said, it disqualifies one who is engaged in an insurrection or rebellion against the Constitution of the United States of America. It does not, by its terms, disqualify one who engages in an insurrection or rebellion against the United States or the authority of the United States. And there is a world of constitutional difference between those two. It is, of course, to the former president's advantage for his lawyers to argue that Section 3 disqualifies one who engages in an insurrection or rebellion against the United States or the authority of the United States. But that's not what Section 3 actually says. But in both litigations, Allie, both parties have focused almost exclusively on whether the attack on the United States Capitol of January 6th constituted an insurrection or rebellion against the United States. And then, as to be expected, the former president's lawyers have argued that, well, no, it was not an insurrection at all. And if it were, the former president had nothing to do with that insurrection on the Capitol. Unfortunately, at least as far as I have seen, the challengers to the president's qualification to hold a future office have essentially bought into that wrong argument by the former president's lawyers, and they, for their part, have been trying to establish that the former president did not incite or participate in an insurrection against the United States. The compelling case under Section 3 for the former president's disqualification is this. His effort to overturn the 2020 presidential election and remain in power, notwithstanding that he had lost that election, constituted a rebellion against the Constitution of the United States and specifically the executive vesting clause of the United States Constitution, which very simply prescribes that the term of the President of the United States extends for 4 years and 4 years only, unless he is elected or re-elected by the American people.
That's Article 2, Section 1, Clause 1.
Because in Minnesota, at least one of the judges on the panel did express some skepticism that they, as in officials at the state level, should be the ones to decide this. One judge said that in her analysis, she found that there are things that, quote, seem to suggest that there is a fundamental role for Congress to play and not the states, that suggests that this is a national matter for Congress to decide, end quote. You and I have talked about this in the past. Obviously, we believe that this will get to the Supreme Court, and perhaps the Supreme Court will understand the argument that you're making about the distinction between a rebellion against the Constitution versus a rebellion against the United States or the authority of the United States. But you have mentioned that a normal reading of the Constitution and the 14th Amendment, Section 3, would say that Congress can make a decision on this front.
I hope I didn't say that, Allie. If I did, I certainly didn't mean it. On that issue in particular, my point is that Section 3 is self-executing, which means in simple terms that it does not require a finding by the Congress of the United States, nor does it require a criminal conviction of the former president for insurrection or rebellion. But going to your larger question, this is exactly what I've seen this week. The parties are confused, and they in turn have confused the courts. So, for instance, the United States Supreme Court will never have any difficulty understanding that the courts, first, the lower courts, and ultimately the Supreme Court of the United States are the proper institutions of government to decide this question.
Don't bet on that.
Why? Because it is a pure question of constitutional law whether the former president engaged in an insurrection or rebellion against the Constitution of the United States. In legal parlance, this is not a factual question, nor is it a mixed question of fact and law. Again, to my main point, the former president undertook or engaged in a rebellion against the Constitution when he tried to remain in office, notwithstanding that he had lost the vote of the American people. That was a violation of the executive vesting clause of the United States Constitution.
Article 2, Section 1, Clause 1.
You didn't say that it would fall to Congress. You did use the term self-executing. This is why guys like me should never be anywhere close to the law, because that's what I took it to mean. But you're 100% right. You said that it is self-executing, and I appreciate your clarity on that, sir. Always good to see you, Judge. Thank you for being with us. The Judge Michael Luttig is a former federal judge for the United States Court of Appeals for the Fourth Circuit, and he is our go-to when it comes to this particular issue of whether Donald Trump is qualified to run for or hold office under the 14th Amendment of the Constitution. Thank you.
Here is where you can find the entire MSNBC interview. There's a timestamp at the bottom end of the URL, which is 132 seconds in. That basically skips much of what Velshi says in running his mouth. The issue here is pretty clear. The Colorado ruling finds that Trump engaged in insurrection, and then it tries to exclude it because he's not an officer of the United States. The presidency is not an officer of the United States. Well, in a case, Supreme Court case, let's just call Buckley. They define that the presidency is an office of the United States. And then it tries to say that the oath is different because it uses the word defend, protect, and defend. Protect and defend. Well, instead of support. Well, an ordinary dictionary definition synonym of defend is support. So, what the judge did in Colorado was kick the can up the road. A good bet is it was fear. She didn't want to be the one who dropped the hammer. And according to Judge Luttig, there seems to be a problem anyway, in that how Crew prosecuted it was not about against the Constitution of the United States. It was against the United States. It was incitement to insurrection. And that's what the Colorado court found, that he engaged in insurrection by incitement. On judicial notice, a federal court might work with it. We'll see. Now, here's a segment of an interview where Lawrence Tribe explains how Section 3 of the 14th Amendment came to be and why, basically, it doesn't belong in the courts, because Congress wrote it in such a way because they didn't trust the courts. Didn't trust the courts or legislative branch to charge people who were attacking the U.S. government. And so it was written in a way to be self-executing, and its appellant power, its appeal jurisdiction, goes back to Congress and Congress only. Of course, everybody's ignoring that right now. I'm not surprised. After COVID and how the whole country just got stupid behind that, eyes are open in a completely different way. And off the cuff, by the way, a simple solution to COVID was copper sulfate. It's been used for 5,000 years to kill viruses, and it kills almost all viruses, including Ebola. I mean, you can, and it's cheap, and it's a little blue powder, and it's very nasty, it's terrible, but it kills it immediately. Now, that's what Trump probably was trying to refer to when he said bleach, just drink a little bleach. Of course, he's so stupid, he got it all wrong. But back to the issue at hand, Professor Tribe explains that this is why the 14th Amendment, Section 3, was written the way it was, so that it would self-execute. Now, this segment of the interview, which is being done by a young guy who doesn't know his tail from which end of the hole it comes out of, is making the argument of shouldn't the voters decide, and how can you just stop a candidate from running? And, this is what's wrong in America today. People don't want to follow the law. The law is the Constitution. If you're going to live here, the Constitution is the Constitution. You want to change it, get enough people together and get a constitutional amendment. Now, if enough people agree with you, then the Constitution can be amended and can be changed. But right now, the law of the Constitution is, under Section 3 of the 14th Amendment, is that if you engage in insurrection, you're barred from office forever. That also applies to being charged with insurrection or any interference with any government function, because the section also says, or the laws thereof, or I should say 18 U.S.C. 2383, upon which the criminal version of Section 3 of the 14th Amendment is drafted, says, with the United States, authority of the United States, or the laws thereof. And also says that you can engage in insurrection yourself personally, or you can give aid and comfort to those who are. And this is where the Colorado ruling is on a little bit of murky ground, but it's solid enough to hold Section 3, 14th Amendment, as a valid application to Trump to bar him from office. More importantly, when he was charged in his second impeachment, and people are looking at it backwards, he was charged with incitement to insurrection. No clause, no article or section or clause was cited, but incitement to insurrection can only be in 18 U.S.C. 2383 because that's the only place in the law where the word incite is used. And it carries an automatic bar to office. 18 U.S.C. 2383 is a little funky in that it's a definition and a sentencing statute. It doesn't tell you how to prove it. And that's where Judge Luttig explained in the previous clip that Jack Smith charged the counts that are necessary to prove criminally that 18 U.S.C. 2383 was violated without mentioning it. Because if he had mentioned it, as Judge Luttig said, he would have walked right into a First Amendment violation argument by Trump. And this is where the Colorado ruling is unique in that it does say that his free speech does not protect him from inciting the riot, which was always called the insurrection. Now, what went on was a riot. They went to the Capitol to try and stop the counting of the votes. Trump didn't do that. He incited it. But the issue was, he then gave aid and comfort by not stopping them. Once it was in full-blown, carrying on, all of his aides and everybody said, you need to tell these people to stop. You need to post something on the internet, blah, blah, blah. And Trump refused. Now, the Colorado ruling comes behind a case that went on for a week. And I don't have all the transcripts or information, but the judge writes that Trump engaged in insurrection because he incited it, basically. The place where she kicks the can up the road, and in such a clear and defined way as Professor Tribe says, it's such a thinly veiled thing that it's doomed to fail. Any appellate court would have to say, well no, he is an officer of the United States, because, quite frankly, it's defined by the Supreme Court that the United States officer is anyone who holds an office. So no one can deny that the presidency is an office of the United States. And then her argument of the oath is just specious in that, come on, I mean, defend is a synonym for support. So she knows it's going to fail. She just was probably fearful, like Senator Romney says, many senators said, think of your children, man, because she knows that Trump supporters would be after her. And these people get in their car and they go home at night. They need to go to the, supermarket and shop. They don't need some unhinged person stalking them, tracking them down, trying to kill them because Trump is a criminal and they're supporting a criminal. What the United States needs to do is stop screwing around with this and go after these insurrectionists, all of them, and anybody who supports Trump, and anybody who gives them money. They all fall under 18 U.S.C. 2383. They can all be fined $1,000 or more for supporting Trump, and they need to shut down Truth Social and stop all this, mealy-mouth crap about First Amendment rights, because there is no First Amendment right to preach hate speech and do hate actions and to incite violence. None of that is a First Amendment right. But for some reason, the media and the courts are chicken shit about it. That's the problem we have. So, listen to Professor Tribe here.
Much harder. It's not a simple mechanical thing. That's what makes this an interesting and difficult lawsuit. In the first instance, as the Colorado voters who have standing in Colorado to sue the Secretary of State to tell her to do her job, in the first instance, she's supposed to decide, and if she won't, the state court in which it has been filed in Colorado will hold a hearing and it will render a decision.
It's a mandamus action.
The reason that it doesn't matter whether he has been criminally charged with insurrection, much less convicted, is that this was deliberately put in the Constitution at a time when we couldn't trust the chief executive and the Justice Department to charge people. Andrew Johnson, who was basically a Confederate, had become president after Lincoln's assassination. He wasn't going to have people prosecuted in the Confederacy. In fact, he pardoned the ones who had been convicted. The
Sounds like Trump.
Wrote the 14th Amendment very deliberately, and the history is clear. They very deliberately said we can't rely on the executive branch and its prosecutions when it comes to disqualifying people from office who have taken an oath and then turned tail on the Constitution and basically waged war on it. Doesn't matter whether they're indicted. This isn't a punishment. It's simply, it's like saying if you've had 2 bites at the apple, 2 wins as president, you can't run a third time. I think you worked for Barack Obama, a very popular president. If the Democrats decided that Joe Biden was a little too old and they wanted to put Obama forth on the primary, it would be a relatively easy matter to say he's not eligible. This is not so easy.
Yeah.
But the fact that it isn't easy doesn't mean it shouldn't be done. We've got to enforce the Constitution. A lot of parts of the Constitution are a little blurry, like the meaning of liberty, equality, privacy, equal protection. This is a little bit like that, although wherever you draw the line of insurrection, if this was not an insurrection and if Trump didn't lead it, then I don't know what is or who would be a leader of an insurrection.
What to your mind is the insurrection? Is the insurrection what happens at the Capitol on January 6th? Is it the effort to do fake electors? If there had been more security on January 6th and people weren't able to get into the Capitol, would you still believe Donald Trump had engaged in an insurrection?
But it would be a slightly harder case because insurrection usually means force and violence. But here the insurrection was the whole plan from the beginning to the end. Fake electors, pressure on Raffensperger, pressure on the vice president, the gallows that threatened him, and then if he didn't give in, the mob that almost got to him and threatened his life. That whole course of conduct was an insurrection against the Constitution of the United States. It's hard to draw lines. Maybe if it had been a much less elaborate plan, maybe if it hadn't included attempts on to kill the vice president and pressure on him, maybe it would have fallen short of an insurrection. But wherever the line is, the argument that is going to be considered by the courts of Colorado is that this falls on the insurrection side of that line.
Okay, here's where you can find the entire interview. And, you know, I'll be honest with you, I don't like the little snot-nosed kid who doesn't seem to understand what law is. It's not what you want it to be, it's what it is. This is the law of the land that has kept the country together for 250 years. While all around the world, Russia has fallen twice. It's on its way to falling a third time because it's an autocratic dictatorship and a very brutal society at that. And China is coming apart because of the same thing. They don't know what human rights are. And the issue is pretty simple. The Constitution is what it is. It is the protector of America. Without the Constitution, we would be a banana republic. And these people who don't understand that you just can't ignore a part of it, you know, because, you know, you want to practice forbearance so you don't think it's fair, they just show their lack of education and, frankly, that they're nuts. Mr. Trump was the worst president America has ever had. And why is that? Because he's inherently dumb. He is stupid. He's a manipulating mob boss type of person. And for some reason, you know, like recognizes like. Many of his supporters are just like him. And that's where we have a problem. Everything Trump says is not about making America better. It's about his form of retribution. Now, this is a big podcast. The timestamp goes in at 29:25 seconds. The rest of the podcast, which is God Save America or Pod Save America, is something else. You can watch the whole thing by removing the timestamp of the ampersand T equals 29:25, and it'll go to the beginning, or you can simply slide the bar at the bottom, a little red bar at the bottom, to the beginning, and it'll start from the beginning. This podcast, this interview was done right after the Colorado suit was filed. Now we have a ruling, and any court can pick up that ruling, take judicial notice of it. Notice that the error in it is defined by a United States constitutional ruling from the Supreme Court defining that the presidency is an office. They can apply that, and then they can apply the ordinary definition meaning and use it to bar Trump from the ballot. If we get lucky, Jack Smith and Tanya Chutkan will do that. They've been sent a little nudge to consider that. We'll see what happens. He's already going down that path anyway. You know, it's either a win now. This could be a win before Christmas without convicting him, if they argue it right. Or in the trial, because this same thing is going to be heard again. That was just heard in Colorado. It's going to be heard again. Same thing, only on a criminal perspective. A little more detail. It's the same thing. It's the January 6th committee report. the Colorado case based on the January 6th committee report. Jack Smith's D.C. indictment, January 6th committee report. D.C., the indictment in Georgia, same thing, January 6th committee report. It's just that in Georgia, Fonnie Willis has pulled it out, called it RICO, and named all the co-conspirators to get them to flip on each other. Her term ends in 2025. So if she doesn't get a move on, the whole thing's going to die on the vine. Judge Eileen Cannon is Trump's friend. She's dragging her feet. But Judge Chutkan is there for life. She could, tomorrow, on her own motion, take notice of the Colorado case, and she could rule, correct the order to federal standards, and she has a duty to do so, and command federal mandamus across the entire country that Trump will not be on any ballot because Section 3 of the 14th Amendment bars him. Now, that's the power of a federal judge versus a state judge. That state ruling goes nowhere. Even the Supreme Court in Colorado goes nowhere. The ridiculous thing going on in Michigan goes nowhere. And why is this all happening? Because they're all chicken shits. They're scared. Jenna Griswold, Secretary of State, Colorado, scared. The girl in Michigan, Jocelyn Benson, scared. I mean, she was in front of a hearing and stood up there about how they were all at her house and she was terrified and that, you know, she's scared. Adrian Fontes, new in Arizona, scared. You know, this judge in Colorado, you can bet she's scared. She went as far as she felt she could go, and she said, I'm going to kick it up the road to somebody else to finish it off because I don't want them coming to my house. It's a sad state of affairs. Judge David O. Carter, California, he couldn't dismiss the case fast enough. And when a motion to intervene to correct it to federal mandamus was filed, he dumped it. He dumped the case immediately. Okay, this is the power judges have. But they go home at night in their little car like everybody else. They don't want some crazy after them, like what happened to Nancy Pelosi's husband. And, you know, this final clip is about just that. How much terror is being levied by Donald Trump and his supporters. It's just that it seems nobody knows how to stop it. The U.S. Attorney Matthew Graves in D.C. scared. They had so many threats prosecuting all those people in the D.C. indictments for the January 6th riots. He was asked and moved to bring quo warranto complaints against the members of Congress. Silence. Scared. He went into a hearing behind closed doors, allegedly, but it was leaked. He said, we're scared. We don't even know where these people are or where these threats come from. So, unfortunately, this is where Joe Biden is too old. He is not dynamic enough in his thinking to know how to solve the problem. You cannot solve this problem with a slow burn. He's over there in Israel trying to tell Netanyahu, man, you got to stop bombing them. You got to stop. And it's getting through to Netanyahu, and he's understanding that the world is turning against Israel. And this is where old Joe Biden is like, slow old man. He's getting the job done. Whereas if it were Trump, we'd probably be in World War III by now. Absolutely. He did a slow burn with Ukraine. But first he had to find out what they're going to do. Could they be trusted? Would they start using our weapons directly against Russia? Will they follow the rules? Okay, it took too long. But Ukraine is winning. And in the meantime, you got these knuckleheads in Congress, these Republicans, who I'm sure don't even know which end their underwear is put on from, who are hollering, save money, blah, blah, blah. No. They're the ones that added $7 trillion to the debt. On one hand, when the Democrats are in charge, the Democrats are monsters, and they're spending too much money. On the other hand, when they're in charge, they do exactly the same thing, except they give it to rich people. We see the mess. And now they've turned into terrorists because they know if something like the national popular vote comes into being, they will never occupy the White House again. Joe Biden beat Trump by 7.4 million votes. No, he didn't. He beat Trump by 24,000 votes across 3 states that if he had not have won, Trump would have been the president again. Trump used that same tactic, and you can find it in a documentary called Unfair Game, How Trump Won. You can look it up on YouTube. And it shows that he used, in the 2016 election, he used Facebook and targeting specific people by watching their social media presence and what they do and what they talk about to target emails directly to them, along with Jill Stein, who was a spoiler, who took enough votes from Hillary Clinton to cause Trump to win. Now, Stein is running again. She still doesn't get it. She's like a knucklehead. Talking about people need choice, blah, blah, blah. It's a two-party system. You're not going to get away from it. You can't, a couple of thousand votes for somebody for president is just stupid. You have a choice between 2 people. The other 2 who are trying to run as independent and green, they don't matter. What they do is they draw votes from the right person to give them to the wrong person. Well, here's the next and final video on the issue of how America is being terrorized and will be terrorized in the future if somehow Trump stays on the ballot. But I don't think he's going to make it to the general election ballot. He may be on the primary, and he may not do that well. You have to remember, not a single vote has been cast yet, and everybody's jumping up and down like the sky is falling. Who does the polls? How do you know they're accurate? People are trying to count old man Biden out. All he's got to last is 4 more years. And even if he doesn't, I think that Kamala Harris has got enough sense to know she don't want to be president. I think she's got enough sense to be president, but she knows that she needs to get somebody else in there to be president. And if he were to die in office, it's better than having Trump in office at all. Play this next clip.
It has become too routine. And breaking just a short time ago, he attacked the judge overseeing his civil fraud trial, New York Attorney General Letitia James, and the law clerk on the case, smearing her by name in a deranged social media post. So there was reasonable cause for alarm this week when a New York appeals court paused the gag order that had barred Trump and his lawyers from speaking publicly about court staff in that case.
Just hours after the ruling, Trump began attacking Judge Arthur Engoron's law clerk yet again, calling her a, quote, Trump hater. And senior Trump advisor Jason Miller said the clerk was a partisan attack dog and a Democrat operative. These are, as I said, just part of a much broader escalation of the ex-president's attacks on his perceived political enemies. It follows his vow to target groups he characterized as vermin in America, a threat President Biden slammed as Nazi-esque. Now, the rhetoric prompted the Washington Post to describe Trump's language as echoing the dictators, Hitler and Mussolini. Now, for the record, a Trump campaign spokesman called the comparison a ridiculous assertion from snowflakes whose entire existence will be crushed when President Trump returns to the White House. Also this week, Trump reposted a social media comment suggesting Letitia James and Judge Engoron should be put under citizen's arrest. And this all happened, as I said, just in the last week. It's important to note here, as we have, frankly, way too often, that there is an established pattern of action taken by Donald Trump's followers when he targets his perceived enemies. In the 2 days after Trump posted, "If you go after me, I am coming after you" on social media back in August, a man from Alabama and a woman in Texas sent disturbing, violent threats to both the Fulton County District Attorney Fani Willis and her office. Now, Donald Trump knows his supporters listen to him. He doesn't stop. On Monday, a federal appeals court will hear oral arguments on the gag order that Judge Tanya Chutkan placed on Trump in the federal election interference case. And that gag order also has been paused while the appeal is being considered. In a 67-page document filed this week, special counsel Jack Smith's team argued that Trump's attacks in that case were part of a pattern stretching back years in which people publicly targeted by the defendant are, as a result of the targeting, subject to harassment, threats, and intimidation. The prosecutors added that Trump is implicitly but unmistakably encouraging his supporters to act against the very people he targets. Now, Trump won't stop the attacks on his own, so the courts have an obligation, with this mountain of evidence before them, to actually make him stop. Joining me now are Michael Steele, an MSNBC political analyst, former RNC chairman, and former Maryland lieutenant governor; Christina Greer, a Moynihan Public Scholars Fellow at CCNY; and David Henderson, a civil rights attorney, former prosecutor, and a CNBC contributor. It's great to have all three of you with us. Michael, I'll start with you. It's not surprising that Trump has gone after Judge Engoron or his law clerk. I think anyone in this country would not have bet against him doing it yet again. But talk to us about this danger again, given how we have seen Trump supporters react to these attacks before.
It's enormously dangerous. I'm just shocked that we've allowed this to get this far. I'm just going to use my best analysis that I can give you at this point on this situation with Trump and his attacks on the judges. Put his ass in jail. That's how you end it. That's how it stops. Now, yeah, people will be mad and they'll be upset, but there is no other person on this planet, and certainly not in this country, who would be given the kind of grace that Donald Trump has been given to run his mouth the way he has, attacking the clerks, attacking the judges, attacking the prosecutors personally, threatening them. We've shown the evidence when he does that, how his base responds. And so the system is getting pulverized from within by Trump and is being pressed to the umpteenth corner it can go in trying to appease him and allow him to be free while he's still behaving this way. So if he wants to continue in this vein, then use the system the way the system would be used against all of us on this show right now. Because you know damn well if any one of us said half of what Donald Trump has said, we would not be on air tonight. We would be in a jail cell. We would be shut down.
People have been in a jail cell for a lot less, I would argue.
At this point.
Yeah, I was saying people have been in jail for a lot less in terms of for violating gag orders and such. But David, speak to that point that Michael raised there, that he should be put in jail because of all of the violations. And yet somehow there's two parts to this. There is the constant attempt as a legal strategy to challenge everything that comes out of a court and just delay, which, as we are now seeing, this is going to take time to play out. but at the same time, the real life danger that is now being posed to these officers of the court.
Eamon, I'm going to repeat something I've told you before, and that is, at the end of the day, he's calling their bluff because he knows that they won't do it, and that's why he keeps engaging this behavior. It's an understatement to say that if anyone threatened a judge or a member of the judge's staff, they're leaving their courtroom in handcuffs, period. I've seen people get locked up for far less than this for violating those types of conditions, but this is what it becomes when you don't do that, because legal decisions, when you're actually in a trial, rest between law and common sense, and sometimes it feels like never the twain shall meet. This is the legal equivalent of Chernobyl. And by that, I mean you've got somebody on the ground making decisions that are being second guessed by people on high who aren't directly exposed to the problem. As a result, you're going to have an explosion, and the aftermath will be just as bad, if not worse, than the explosion itself. So you have judges who instituted gag orders, and they're not only thinking about the First Amendment. They're also saying, listen, I am in the courtroom. I see the looks. I hear the exchanges that are happening at the bench. I see the way people are behaving in the hallway and at counsel table. And I'm telling you, the situation is going to explode. Then you get appellate courts who stop those gag orders because they're saying, well, from an academic point of view, maybe you should have the right to say some of these things. But it brings us back to the first situation when you're doing things like endorsing citizens' arrests, that's not just complaining about your circumstances. You are inciting people to take action that will lead to violence when there's an established pattern of having seen it happen before. And we have a responsibility to not let this get further out of hand. At this point, we're as much of the problem as he is.
Yeah, we're a society that has become complacent to this, and that's the dangerous part, Christina, because no one has stopped Trump before, despite the documented history of his supporters taking action when Trump when Trump speaks. We have seen it time and time again, and yet nothing changes.
No. And Eamon, we have to remember, Donald Trump is not new to the courtroom. He's been in and out of the courts ever since he's been in our political imagination for decades now, because he's been lying, cheating, and stealing and grifting all across New York, and now it's just gone national. I think, though, we need to expand the point. It's not just about speaking out of term against, the prosecutorial judges and clerks, but also the attorney general, the racist and sexist comments. And the call to action is actually a call to arms. We've seen Donald Trump incite his supporters. He wants this. He wants to be televised. He wants to make sure that in the court of public opinion, he's seen as the hero and the victim simultaneously. And so, as was said, the horse has left the barn. I mean, it is so far away from us at this point because Donald Trump is now controlling the narrative. He knows that he probably won't be put in jail for contempt of court. And so he just keeps pushing the envelope. He's done it with policy and conduct and norms when he was in the office. And now that he's no longer in office, he's doing the same thing in courts all across the country. And so I don't know how we put this, dare I say, genie back in the bottle, but I don't know how we retract sort of what Donald Trump has pushed us into, and all that he's excavated, all the negative sort of vitriolic, racist, sexist, homophobic, anti-immigrant, anti-Muslim sentiments over the past few years. And as Michael said, in some ways we've become numb or immune to it, which we cannot if we expect this democratic republic to succeed in any way, shape, or form.
So, and to Michael, to David's point about not just the threats to the officers of the court, but in Jack Smith's team in making the argument for reimposing the gag order, they're saying this actually amounts to witness intimidation. So it's not even just about the gag order for the safety of the people. It's actually the assault on the judicial process in our country, that a witness in his trial will feel intimidated by what Donald Trump is saying right now, and that could impact whether or not the wheels of justice actually spin as they're supposed to down the road.
Absolutely. What you're seeing is sort of a trifecta of moves all simultaneously. One, the first order is the attack on the judge and the clerks. The second is the attack on the prosecutors and those who are bringing him to court, right? Those who are bringing these charges against him. And the third is everyone else. And that everyone else involves a pool of people who will be called and brought into a courtroom to serve as judges, as jurors, and also the witnesses that may be participating, but more to the jurors, more to finding that one person who in all the cases would say, no, he's innocent, and throw the whole thing out.
Yeah.
And so Donald Trump has been from the very beginning very much, and I love this idea of, his trying to be both, the hero as well as the victim. That's what he's trying to do. And he's trying to use the system against itself. And by the time you get into that jury room, you'll have that one person who is so hell-bent on freeing Donald Trump, like freeing Willie, right? That you wind up with these mistrials. And again, he will be the one who will be saying, I told you so. But it's I told you so based on all the crap he's doing right now. Because if the system doesn't clamp down on it, the back end of this looks incredibly ugly.
Mike, I can't let you invoke Free Willy in this. That's a great movie, and that whale does not deserve to be compared to Donald Trump in any of this, in any of the situations.
But a whale's a whale. So.
I got to ask David from another point, which is what we heard earlier this week, Judge Engoron rejecting this attempt by Donald Trump's team to seek a mistrial. And that kind of had me wondering a little bit, because the judge, or I should say that they were arguing that the judge and his clerk are biased against Team Trump. Is that part of the strategy here, that if I can assault this judge verbally, if I can get under his skin, if I can provoke him to do or say something irrational, I can then use that in my appeal to say, look how he's talking to me. Look how he's trying to curb my rights. Look how he's insulting me. Look how he's voting against me, that this trial is not being dismissed.
Amen. I'm inclined to say yes, but I'm not going to say that I think that he's that intentional about the way he goes about this. And the reason I say that is because I was a prosecutor. I was a special crimes prosecutor. I dealt with lots of people who committed acts of domestic violence. Often other issues were associated with that, similar crimes like sexual assaults. I've seen how people who bully and intimidate behave, and I'm not willing to say that they're always necessarily thinking about what they're doing. But with that in mind, sure, goading the judge under these circumstances where not only is a judge taking actions that are only intended to keep people safe. You're dealing with someone who's going out in the hallway, talking about you, talking about the people who work with you. You're taking steps to keep people safe as best you can. Then you're getting second guessed by a higher court who's saying, okay, let's stop this gag order for right now, and who then may in fact overturn it. Everybody has a point at which they will break. And so, yes, I could see that being part of what someone may have in the back of their mind. If the judge snaps and says something, right, maybe it at least gives us leeway to cause an additional problem that further gums up the works.
Yeah, that's the fear, is that he can point to it, or his team can point to it and say, look, the judge is biased against me. But to your point, I'm also not sure that Donald Trump is that smart, certainly maybe maniacal, but not smart on that front. David Henderson, thank you very much, my friend. It's always great to see you. Michael, Christina, please stick around after the break. Some new reporting on how Donald Trump and his allies are preparing for an even more radical and dangerous second term. This is out with a new report pulling back the curtain on Donald Trump's plans for a second term. According to the outlet, the disgraced ex-president and his allies are currently spending tens of millions of dollars to pre-screen the ideologies of thousands of potential foot soldiers as part of an unprecedented operation to centralize and expand Trump's power should he retake the White House. Their goal? Rip off the restraints imposed on the previous 45 presidents and help Trump carry out his radical second-term agenda. It is an agenda that has come more into focus over the last few weeks, thanks in part to several bombshell reports from the New York Times. Here's just some of what we could expect from a second Trump presidency. The disgraced ex-president wants to use the Justice Department to carry out his own personal revenge missions, using the power of the federal government to take vengeance on his political adversaries. He also plans to carry out an extreme immigration crackdown, including erecting sprawling camps to hold undocumented detainees. Now, to accomplish these radical policy goals, Trump and allies are looking to purge career civil servants from the government and replace them with Trump loyalists. They will also want to install more aggressive and ideologically aligned legal gatekeepers throughout the government who will carry out Trump's plans with no questions asked. A second Trump presidency truly runs the risk of ending American democracy as we know it. That is not hyperbolic. Let us bring back Michael Steele and Christina Greer. Also joining the conversation, Ruth Ben-Ghiat, a professor of history at New York University and an expert on authoritarianism. It's great to have you with us. Ruth, let me start with this Axios report, that this Trump allied machine that's kind of now beginning to spin has the most power over the formation of a potential future government of any group in U.S. history. Just put this reporting into perspective for us. Is this effort from the ex-president and his allies something that is unprecedented as it seems on the surface, given the fact that our country has not had presidents who have lost and then come back to win re-election?
Yeah, well, Trump is an autocrat. He's not a Democrat. And so what he's doing here is straight out of the history of authoritarianism. And so it's not just the content of what he wants to do, the mass deportations, the mass detentions, and also, if you get into it, he says he wants to expand psychiatric institutions to put people in there. That is what authoritarians have always done. And he mentioned Jack Smith. So, locking up and declaring insane an investigator is exactly what authoritarians do. The communists in the USSR routinely put dissidents in psychiatric institutions. So it's not even just all that, it's the method, because autocrats need a compliant bureaucracy to implement their repression quickly. And so they need lawless and corrupt people who are not going to have pangs of conscience. And that's what happened the first time. And he's learned from that. There were too many civil servants who actually had some ethics, too many lawyers and so this time he's not making that mistake. And it's like seeing the corruption chapter of my book come to life, because I wrote about this, that you must have lawless and corrupt people in government in order to have an autocracy.
You bring up such an interesting point, Ruth, but tell me, and you're certainly more of an expert on this than I am, there's a false perception, I think, in our society that we have such strong democratic institutions and we have such strong guardrails that our democracy has survived for 250 plus years that it can't simply be undone in the span of 4 years by one man and his cohorts. But the truth is, our institutions are vulnerable. They can be co-opted by a handful of people. Am I wrong in making that assessment, or do you think that our institutions are resilient enough?
No place is immune to and perfect in terms of that. We got January 6th because he already did a number corrupting the GOP and all the other people who contributed to that coup that almost had success. It came far closer than people know. So we're already quite along the way, and he intends to pick up and accelerate, indeed, everything that he was doing in Trumpistan 1.0 would be Trumpistan 1.2 would leave us by 2026 looking, on the road to looking like Orban's Hungary in ways that Americans are not prepared for.
Michael, NBC News is reporting that donations have surged to groups linked to Project 2025, which is seeking to create a government in waiting for the next Republican presidential administration. Does it worry you the sheer amount of energy and power these conservative groups are putting behind this effort to fill the White House with an army of yes men who fundamentally are undemocratic?
Yes, it does. Emphatically, it does. And it does for a number of reasons. The first being, people need to listen to Ruth. They need to read her book. They need to listen to what she is telling us and what those in this space who are looking at this democracy from the inside out are trying to warn us about, because it's real. These folks they learned a lot from January 6 people, and they're not going to make the same mistakes again. I'm sorry, the revolution will not be televised, nor will it appear on Facebook. They have learned. They're not going to tweet about it. They're not going to text about it. They're going to create the institutions and the infrastructure away from your face, away from your prying eyes, so you are caught by surprise as much as possible. Groups like this, this Project 2025 that are sort of planning it. They're raising the money. And that money is going to be spent, and it's going to be spent against the American people, against the very institutions you think have been safeguarded against what's about to come. And it hasn't, and it isn't. Our institutions are only as strong as we are. And the fact that we have a significant number of Americans who are more worried about, the price of gas and inflation, not taking away from the importance of that, but relative to the democracy and the threat that's in front of us that's being reported out every single day, the man is telling you what he wants to do. He's telling you who he wants to do it to. And he's not even giving you a reason why. He's just saying it's going to happen. And you look at Joe Biden and go, well, he's just too old. I swear, I don't know what I'm going to do. Well, what you're going to do is you're not going to vote for Donald Trump. And that's what this election boils down to. That's what these moments boil down to. And people need to realize Ruth is not on this show just because she got nothing to do on a Saturday night, right? She got a lot to do, and she's been doing it. Read the books, listen to the smart people who are telling you firsthand from their experience and from their study and from their listening and their watching what is about to happen.
First of all, I second your statement there that Ruth has a lot of better things to do, but our democracy is at stake. So we appreciate every minute of her time ringing the alarm bells as loud as possible for everyone who is watching this. And unfortunately, Christina, there are people who are watching this and probably are listening to Donald Trump. He's not exactly hiding these intentions on the campaign trail. I mean, his first rally of his 2024 presidential campaign, this is a guy who stood up in front of a crowd and literally declared, quote, "I am your retribution." He's telling the country exactly what he wants to do. And I worry that he's kind of numbing people into it. And that is what concerns me. People out there listening to this is like, Trump's just being Trump.
Yeah, well, Eamon, he began going down that gold escalator calling Mexicans rapists. And journalists and, voters were like, oh, that's inappropriate. But ... And then we saw him go through the campaign, systematically pick off his Republican contenders. And then he was the nominee. Well, he couldn't really become president. And then he became president. And he was caught flat-footed. And so what makes this moment so dangerous and horrifying, realistically, when we think about Agenda 47 or Project 2025, it's because when Trump was first president-elect, he wasn't prepared. He didn't have any people in position for a transition because he really honestly didn't think that he was going to be president. You saw his face on election night. He was as shocked as we were. And so there were so many times where we either had whistleblowers, people who cared about this country, cared about the future of our democracy, who sort of put the brakes on some of his proposals. We had some people in his inner circle who said, sir, we actually just can't do that. They would be fired or they'd quit. He'd get someone else. But slowly but surely they eroded things. But many people in his inner circle at least said at certain points in time, far, too late. But they did say, I'm not going to do that, or that's too much. I mean, we remember Jeff Sessions. We thought he was the worst person on the planet, and then rolls in Bill Barr. So it gets, right. There's always a greater abyss. But this time, he knows what a transition looks like. He knows who he can put there. He knows he can fire lots of African-American women who were loyal soldiers, within the sort of middle and lower rungs of government who actually said, no, we're not actually going to, put through your proposals. We actually work for the American people. We don't work for you. And so he now knows, well, if I just get rid of that entire swath of people, I can actually just do what I want. And so there's a certain level of knowledge that he's coming into this second race with that makes this a much scarier time than 2016. 2016, he knew nothing. Now he actually has 4 years of preparation and 4 years of reflection and sort of revenge making that he's been working on. And so it's imperative that voters actually pay attention, which sadly they are becoming immune to him and his antics in many ways.
I've made this point really quickly previously that it wasn't Mike Pence that saved us on January the 6th or saved our democracy. It was Dan Quayle who managed to convince Mike Pence to not overturn the election. That's how close we were to losing this democratic experiment of ours. Ruth Ben-Ghiat, thank you so much for joining us on Saturday night. We certainly appreciate it. Michael, Christina, please stick around. The conversation continues after the break because it's not just Trump acting like an authoritarian. It is his party. We'll tell you more about that. It's not just Trump. Republicans across the country are pushing their authoritarianism to new extremes, including blatant attempts to ignore the will of voters. In the wake of Ohioans voting overwhelmingly to enshrine reproductive rights into the state constitution, 4 state lawmakers said that they are planning to introduce legislation that would strip judges of their power to interpret that amendment. As the Associated Press reports, these Republicans want the legislator, not the courts, not the judges, to actually make decisions about the amendment. A legislator, we should note, that is, of course, dominated by Republicans. Now, the state's Republican House Speaker echoed that idea, saying, quote, "The legislator has multiple paths that we will explore. This is not the end of the conversation." As Mother Jones puts it, the GOP is trying to enforce minority rule. They don't care what the vast majority of Ohioans want on this deeply personal matter. They'll find a way to impose their position, a minority-held view, we should note, on everyone. Back with me, Michael Steele and Christina Greer. Christina, your thoughts on this? Ohio Republicans trying to ignore the will of the voters who have now, in 2 different occasions, 1, rejected a Republican proposal to ban abortion, 2, to enshrine it in the Constitution to make sure that women have the right to an abortion. And now they're saying, no, it's not up to the judges. We're the ones that are going to interpret the law.
Right. Well, we know that the Republican Party consistently moves the goalpost to suit their needs. And I think the real story is twofold. One, abortion is a winning issue for Democrats, and they need to sort of stay the course. This is an economic issue. It's an issue about a woman's right to choose. And so we shouldn't just say it's abortion, because it is really about people who believe a woman should have autonomy over her body versus people who do not believe a woman should make decisions and have autonomy over her body. That is the clear debate. And so I think we need to sort of make sure that we don't shorten it to abortion just because we can actually get some people who are on the fence, and we actually could get some Republican voters, not Republican legislators. Bayman, the issue of a woman's right to choose is overwhelmingly supported by the vast majority of Americans. So when we have this minority of Republican legislators who are so adamant about controlling a woman's body and her right to choose and changing the laws in states at all levels, local, state, and trying to do it on the national level, we have to make sure that we keep people engaged and recognize this isn't the only issue where people will go to the polls, but it is a very key, important issue, especially in odd number years, to make sure that we don't let all of our rights that are hard fought for the past several decades just go by the wayside just because Republicans have chosen to make sure they try and take away. They're the party of regression, of taking all the rights and civil liberties that we work so hard for. They want to take them away when it comes to immigration, when it comes to sort of civil rights, when it comes to transgender rights, when it comes to marriage equity, when it comes to a woman's right to choose. I mean, the list goes on and on. When it comes to education, I mean, the only way they know that they're going to win is either to steal elections, to make sure that Democrats and de facto people of color can't vote, or to keep their voters so uninformed and uneducated they can sort of have them go to the polls and vote against their own interests consistently.
Mike, I got to get your thoughts on this. Rick Santorum, another night on the network, saying pure democracies are not the way to run a country.
Okay, that's just laughable. Look, it's just one more silly, stupid thing that Republicans say to justify what they're doing. Rick Santorum knows damn statement take. And he would never have made it prior to Trump. He never would have made it when he was running for president. He never would have made it during the Reagan years. So why are you making it now? At what point did you decide that a pure democracy was not a good thing? When did that conversation happen? It just speaks to a whole swath of things that we've covered tonight, and in terms of where this is going. This question about what they're trying to do in Ohio with the legislature. The reality of it is folks focus on the fact that, Republicans are losing. They're losing a lot of elections, right? They're losing it at the federal level. Where you need to turn the table in the corner is at the state and local level. The state legislatures you need to focus on, because that's where the rot begins.